It is May 29th of 2026, and this is the Court Gallery. Today's docket is a wild ride. We start with a landlord who may have avoided his own eviction by accepting rent after a tornado scrambled everything up. Then, a woman tries to explain why she was on the run for 9 years, but the judge's math just isn't adding. In Washington State, we'll hear how a defendant earned a $500,000 bond. And we end with a small claims case that gets completely derailed when one roommate accuses the other of being drunk, possibly projecting. You can't make this stuff up, ladies and gentlemen. We have a wild set of cases to review tonight, and it all starts right now.
Although I had a trial this afternoon, and I was going to try to get 2 feet closer to the finish line, but the case had to be adjourned. And so we had scheduled a 4 hours worth of trial time this afternoon, but we've lost that.
I'm not going to lie, Judge. I'm not totally disappointed by that.
Yes, it sounds like you got a little more recovery to do. Vacations are rough. You have to rest up after you go on vacation. Good morning, Ms. Corpenay.
Good morning, Your Honor.
I was actually back last week, Judge, and this seems to have struck over the weekend. We've only got 3 attorneys taking cases in my office right now, based on the. I guess I don't know if you've heard that Don Roberts announced he's retiring. I can't remember if we talked about that last time I was.
I think I knew he was going to.
Yeah, he pushed his. Or I'm sorry, he's not retiring. He specifically said he's resigning, but
No, I hadn't heard that.
Yeah, but he pushed the date back from May 31st to July 31st, I think. And then I believe my colleague Adam was in your courtroom earlier this week, maybe, or no, last week, I think.
Yes, that case is resolved, and I'm very pleased about that.
Yeah.
All right, here they put him in a, so I guess you'd be able to consult with him.
I was just going to tell you, Judge Adam's leaving our office in 2 weeks. He's going to our Grand Rapids office.
Oh.
I know you don't see him very often.
Well, you had got COVID fellow money, and you had extra lawyers and landlord-tenant specific lawyers, and it was a good time, but that money they just printed like turning straw into gold, and that money's gone.
Have a seat.
Okay.
Right there.
Yeah. I can tell you more about that.
Good morning, Mr. Haley.
Good morning, Judge. How you doing?
Welcome to our new old courthouse.
Yeah,
I don't think you've been on this side.
No,
I'm not afraid to have you in the courtroom with me, but also with us this morning is Meg Bauer from Legal Aid, and she is here by Zoom. So if I do need to set you up for a consultation with Legal Aid, I can do it by Zoom, which is why you're in the conference room rather than here in the courtroom.
Right.
Let's talk about your case. This is Signature Enterprises versus Sean Haley. The file number is 26927LT. Attorney Matt Davidson is here with his client, the owner of Signature Enterprises. This is filed as a termination of tenancy case. This is a property on East Street in Three Rivers. Seems like we went through this before. Anyway, they want you to move. They served a notice to quit on you on March 15th. It's now June 29th. This was I think a week-to-week tenancy. There is no lease. So I'm not sure what it was. Anyway, they want you to move. And as such, you have a right to hire a lawyer. If you cannot afford an attorney, you could see if legal aid would be willing and eligible to represent you in the matter, or you could seek other legal advice. You have a right to have the case heard here in St. Joseph County where the property is located.
Yes, sir.
You have a right to demand a jury trial. If you wish to have a jury trial, you must tell me at this first appearance or file the written demand within 5 days and be prepared to pay the $50 jury demand fee unless the judge waives your fee for your inability to pay it. You may be able to resolve the case by going to mediation with your landlord. That has never happened, but it might. And if both parties are interested in going to mediation, the court can make that referral. And finally, you may be able to reach some sort of an agreement with the landlord that means a conditional order of dismissal would be prepared, short of an actual court order or writ. And if that was the case, Mr. Davidson or the court could assist in preparing that. Mr. Davidson, at this point, your client is simply asking for possession of the premises back.
Yes, please, Your Honor.
What's your position, Mr. Haley?
My position is, I really don't understand what he's asking me to leave the premises back. I do want to work for him.
Boy, this is bad. This is our conference room and I can barely hear it.
Yeah.
Why don't you scoot up a little closer to the microphone?
Or judge, have him in the courtroom, and if we need a consult, he can go back out there.
Right. We'll see how this works. All right, Mr. Haley, they want you to move. What did you want to tell me?
Well, I like I said, only like a month, I believe, just 1 month.
All right, just stop for a minute. Just come on in the courtroom.
All right,
Mr. Haley.
All right.
Anyway, good morning. You're Sean Haley.
Yes.
Just have a seat. I've known you for about 45 years.
Stand up here.
No, you can
All
have
right.
a seat. All right. I can hear you better and see you.
Yeah,
Your landlord is asking you to move.
Yeah.
And what's your position?
my position is, at this moment, my rent to him has been direct deposit. It goes straight to his bank. I only missed one month, and that was when the tornado hit Three Rivers and crashed my bank, Central Bank in, and I ended up couldn't get to them or anything, and had to use money to survive a little bit. I thought maybe it already went directly to him, but apparently it didn't. So
Well, at this point,
Instead
he's
of-
not asking you to pay the rent.
yeah,
He's simply asking that you move. Now,
Yeah.
have you paid any rent since March?
matter of fact, today it should go in his account into the
Well,
bank
did
right
you
now.
pay April's rent?
Yes, I did.
Did you pay May's rent?
Yeah, I missed just when the tornado came. That was it. Apparently
Just a minute.
he's upset because I don't do the work, like go cut his grass at his house.
Well, let's
I
see
do
what the deal
everything
is.
else.
Mr. Davidson,
March.
has
Yeah,
accept-
the situation, Your Honor, was that he had the money. I believe he gets Social Security or for whatever the money that gets direct deposited into his account, he would spend it before it got, before the rent got done. And that happened. He brought in part of the month for February, none of the rent for March.
Oh, come.
The rent for April was paid. And I believe that just because it was automatic deduction, it didn't pay just now for April
No.
or for May.
No. I can
But
get bank.
we'd refund it, or I mean, he's behind a month anyway. So as long as he's current on the,
Well, you can't accept rent in a termination of tenancy case after the notice to quit. So he's filed a notice to quit. There's no lease. He's accepted April's rent and now May's rent.
Yeah.
So he's either gonna have to turn this into a termination of tenancy case, excuse me, of a non-payment of rent case. He forfeited his right to terminate the tenancy by accepting rent for April and May.
Yeah.
That's
I
the Park
disagree, Your
Forest.
Honor. Why is the why, Your Honor, is the if he terminates his tenancy, he couldn't keep his rent current? I believe he can. The termination of tenancy is not about rent. If he has a termination of tenancy, as long as he's current to the date of the eviction, that's legal. He doesn't have to not take rent in a termination of tenancy as long as he's not behind, and the person was behind to begin with, so he's still not current.
No.
Termination of tenancy is not about rent.
Mr. Davidson, I'm sorry. You're absolutely incorrect.
All
There's
right.
a case in Park Forest that says when you file a termination of tenancy, you can no longer accept rent.
My apology.
There are some exceptions. But once you accept the rent, it undoes the efforts. So the landlord's in a catch-22. Once they file the termination of tenancy, they can't accept any more rent. So it might take April, May, and June to get the defendant out. In the meantime, the defendant is 3 months behind on the rent. The landlord has missed out on 3 months, and they'll probably never collect it. But I didn't decide the case. That's what the rule is. Meg, you have any input on this?
Yeah, I do, Judge. There's a case subsequent to Park Forest. It's called Aspen Enterprises.
Yes.
It comes down to this. It threads the needle on that catch-22, but it comes down to the understanding and representations to the tenant, and essentially the offer of rent and the acceptance of rent by the landlord, absent a representation otherwise, operates as a renewal of the month-to-month tenancy. So under the facts in this case, I would agree that the termination notice has been waived by the acceptance of rent.
So the question is, what do we do now? Yes, Mr. Haley. So what Mr. Davidson contends, and apparently you acknowledge, you're 1 month behind in the rent, which was March's rent. March 6th, there was a tornado in Three Rivers, which did lots of damage, including almost demolishing the Century Bank and Trust.
Correct.
At 131 in Broadway.
Correct.
And I don't think it's open yet. Now, the whole bank isn't demolished, just that branch. At any rate, it appears you were behind March's rent. They filed the notice to quit on March 15th. They accepted April's rent and they accepted May's rent. So we can either start over again.
Or I can.
Or what's your preference?
Like that month's behind. So each month that I pay, I add another $100 to that until I catch up with the $595. To take.
How much is the rent each month?
$595.
So when you paid April's rent, you added $100 to
I
it?
said like today will be the first. Will be our first, and instead of $595, it will be $695. And each month it will be $695 until I pay that $595.
That's an option.
If they want to go that way. If not,
Now, you mentioned that you thought he was mad at you because you didn't mow the grass and that sort of thing.
but I look at Mr. Ron as like almost like a grandfather. I've been working for him ever since he had 4 or 5 other uh, apartments or places. I've been painting, hardwood floors, carpeting. I still do this. I take care of the building that I'm in right now. I did 3 apartments in there already, and I'm doing the one that I'm living in. I'm fixing it up. I'm the one that's painting. I'm the one that's doing the floors and everything like that. Uh, he got to the point where Ron is really nice, but he got to the point. I am 63 years old. You have to give me respect. You don't come like he walks into my apartment 5, 6 times unannounced. He just comes in, and I said, "Well, this is my house." No, this is my house, he says. And I be I have company or something. You still can. You have to let me know that you're coming to my house. You just don't use your key and walk right in. He
That's
did
correct.
He did it
Now,
the other day.
why don't you have a lease?
They never gave it to me. I went and filled it out at their home, and they never gave me a lease. They said reason why the lease is because it was the first month's and the deposit, and they waived over the deposit because I did so much work. So boom, they knocked that out of the way. All right, I still never got a lease. I'm the only person that they deal with that has a direct deposit, which I didn't understand that. But Ron himself took me to the bank twice after the tornado, before the tornado when it was in Three Rivers, and after the tornado to make sure that the direct deposit goes to his bank. We did that. I had no problem. It started, and I was like, "Woo, that's out of my hands. That's good. I don't have to worry about it." Well, right now, like I said, I like him, and I'm not going to stop doing work for him. But if he really wants me to move, the money that's being direct deposited to him and all that, I have nothing to move with. So 2 or 3 months.
There's several issues. There is no lease.
Mhm.
You're making a direct deposit from your bank to him,
Yes, sir.
which gets his rent paid. $5.95 is about the lowest rent you're gonna find
Yeah.
in St. Joe County.
I
That's
understand.
not subsidized.
Yeah.
So it's gonna be difficult for you to find somewhere to move to. He undid his termination of tenancy by accepting 2 months' rent after he filed the notice to quit. The representation would be that it would then continue again. So I don't really want to make you pay a filing fee and everything all over again, but we can I can just dismiss it because the landlord has accepted rent after the notice to quit. Or I could continue it and allow you to serve a new notice to quit. But then we gotta wait 30 days to set a hearing. You gotta give them 1 month's notice. Also, you can't simply enter his apartment.
Thank you.
He has dominion over the apartment and it's his house. And, Mr. Weiner, I'm gonna put you in the waiting room while you finish your breakfast and then we'll come back in here in a minute. Anyway, Mr. Davidson, what would be your preference here?
Well, I've silently listened. The issue was created by Mr. Haley that it was about rent. There's more going on than just rent, Your Honor. And because of the automatic payment is why we got stuck in being current. Because he was
Yes.
2 months behind, he was spending the money, he wasn't getting the money. And then all
Well,
of a
you
sudden,
don't
and my only point was that he's also removed the sink, torn up the property, he's done other, it's not just about rent. He's making it that, and it's obviously an issue, but the acceptance of the rent happened automatically, which is the reason that, he didn't, wasn't in a position to not.
You don't even need a reason. If you want to terminate it, you can terminate it, but you can't accept rent. Mr. Haley, he's not trying to evict you because you didn't pay a month's rent. He doesn't want to have you as a tenant anymore. One thing you should do is stop your automatic deposit before it makes June's payment. Well, I don't know what to say about it because I'm gonna dismiss this.
I believe they already
They already accepted
I
June's
believe,
payment?
yes, sir. I believe it's already done. If today, for the first is going to be on the Saturday or Sunday, it's already done today.
We'll pay it into the court, Your Honor.
Say that again?
Well, we can't do anything with his account. So
Yes,
if,
that's up to
if
him.
another one
But you
comes up,
can,
we'll pay it into the court. We don't want to accept it. It happens automatically. And we can't stop it.
um,
He said he tried to stop. Mr. Ron here said that Mr. Haley had tried to stop it, but I don't know about
No,
that.
I haven't. No,
And
I have
can't
not.
answer that.
If I would have known to stop it, if this was going to really go through,
all right, well, he wants you to move.
Yeah.
And I guess my advice is you prepare to find a place
I've,
to
I've,
move.
I've been,
Oh, I can't believe they're gonna do this while we're held in court.
I've been looking, but that's going to take me at least 2 to 3 months to get first deposit and the rent to wherever. Like you say, $595. You're not going to find that anywhere. So we're looking at maybe $800 plus $800 for a deposit too. That's I only get
All
like
right, well, we got way out of whack here. We've taken a long inordinate amount of time on this case because it's got some wrinkles to it.
what is your
The
suggestion?
plaintiff argues his money was automatically transferred from his account to my account. And I didn't have the ability to not accept it. So I'm gonna explore
Judge,
that further.
we see landlords return the rent all the time.
What's that, Meg?
We see landlords return the rent or do
Yes.
other things to mitigate this issue.
That's what they're supposed to do. We could pay it into escrow, I suppose. But yes, many rent now is automatic deduction. All right. Plaintiff directed to remit June or
Your Honor,
yes.
he's still behind. So how about if you just dismiss it and we'll start over? Because if you order us to give up money now while he's already still behind a month and a half, that's not fair to the plaintiff. So
I was
just
gonna have you pay it to the court, but yes, all right, dismiss the case. Plaintiff will refile.
and please direct that he stop his automatic rent.
I will.
Yes,
I
stop
will if
your
that's
automatic
yes,
payment. I would direct you to do that today.
yes, sir.
All right, I'll do an order dismissing the case.
Your Honor, with if when I stop the case, the order right now, right? What if that money's already went to his bank already?
Well, then you'll have to deal with that with your bank. Now, one of the issues is if you're staying there, let's say you stop payment and well, right now, if he's dismissing it, you need to pay June's rent.
Yeah, okay.
So
I have no problem.
the case is dismissed, you owe April, May, June's rent. Once he refiles it, then you don't pay anymore.
Yeah.
But if June's rent has already been paid, you're good to stay there through the end of June.
Okay, I have no problem. If they paid it already, I have no problem. See, I have no problem with Ron or Miss Elaine at all. I have no quarrels with them at all. I'm shocked at the way they feel because like I say, I do all the maintenance.
He says you've removed your sink and done some other stuff.
it was old fashioned steel, everything like that. And I bought a brand new sink and I installed it and faucets for that sink in the bathroom because it's an old historical house. And like I said, I did the other 3 apartments. Like I did the floors, I took up a carpet, did hardwood floors, painted everything, all that. There was never a problem. When I told them about that, there was no problem to take out the sink and all that. I did all that, and I'm still working on the place right now, putting towels down on the floor. I don't. If they want me to,
Well, this case is gonna be dismissed. You owe April's rent, May's rent, June's rent. You paid April and May. June may be paid. You're also behind.
Mhm.
So you need to catch up on the rent that's not paid, but they're gonna dismiss the case and start over again. So my suggestion is you start to look for a place to move.
Yeah,
to.
exactly. I am. I mean,
So you got some lead time,
yeah.
but you have to pay June's rent. Once they file another notice to quit, then that forgoes your obligation to pay rent.
Okay.
All right.
Your Honor,
you're
I
good
just
to go.
want to raise one issue. You say he was paid until the end of June. Right now, he's paid halfway through May. So we just disagree with that point.
Well, I'm not clear. He said April.
He's behind,
Yes,
and they made a payment in June, but it's
Yeah.
not for June.
Um,
Current on his
fair
rent.
enough, but anyway, he'll be there in June, so he owes the obligation to pay the next month's rent. The June rent will be applied to May if he's a month behind.
Mhm.
Okay. All right, thank you. All right, Mr. Haley, you're
So,
good to go.
so should I stop my?
Yes,
Okay.
well, you're gonna be there in June, so you
Right.
need to pay the.
I
rent.
like for that to go through already. Yeah.
Then after that, I would stop the automatic payment.
Yeah.
It doesn't forgive your obligation to pay rent. If you're still there in July, you'll owe that month's rent too.
Yeah. I'm going to look for me.
All right.
I don't.
All
I
right, you're
can't
good
go
to
through.
go.
I'm too old to go through that.
Yeah, there's a lot of that going around.
Right. Thank you very much.
Okay.
Ron.
Lori Anderson versus Armani Lime. And here we go.
Good afternoon, Your Honor. Entertaining. Lori Anderson.
All right, where are we on this?
First and foremost, I would like to state that.
Hold on a second. Why do I have this case? Because
What I've done, 5%.
which one? All right. Go ahead. What do you want to say?
I was gonna say that, she has been using my personal information to impersonate me. And she's still harassing me, but never got me. The neighbors have been telling me that as well. We would want to.
I'm here on a writ hearing.
Your Honor, from plaintiff's perspective, this is a writ hearing. We are coming up on the 56-day time period issue. As of our last hearing, we acknowledged that the defendant had made a $7,600 payment towards the rent that was owed when this case was filed, leaving a balance on that particular judgment of $4,107.37. The court was adjourned that so that that amount could be tendered to the plaintiff. Thus far, we don't have those funds. And furthermore, Your Honor, there's currently another 3 months worth of rent due.
Are you going to pay off this judgment?
I'm sorry, what did you say?
Are you going to pay off this judgment?
I'm going to pay it, but it's not right. I would like to go over it since I do not owe that much.
Okay,
there that I would like to look over and see something about repairs, but nothing was repaired. So I'm trying to see where the extra money is coming from. Still paying the water.
Lyman, this judgment was issued in March.
I have 6,600 to pay, but I would like to see everything before I pay it, so I just don't need.
That's the judgment. I'm not disturbing the judgment.
Well, it's not right at all. Cause I should only hold 1,000.
I'm not disturbing the judgment. Judgment is what it is. I don't have anything filed indicating that I should even look at that judgment. That's what the judgment was issued for. I'm now in May. If you pay off the judgment, they got to figure out what they're going to do.
I emailed the court the day of when that happened, saying it wasn't right.
All right, let me just be clear. I'm not doing anything with the judgment. You can keep talking to me about it if you want, but I'm going to tell you the same thing. So your choices are you either pay off the judgment or I just deny this and they're going to go forth and do what they got to do. So which do you want to do? There is, you said 4107
37 on the
on the judgment.
on the judgment.
You said 37 or 40?
$4,107.37.
Okay. I think we were starting at the wrong one. All right. Are you going to pay that off? When are you going to do that?
66 that I can turn in next week.
Well, I can't. Lyman, I thought you said you had 66. Do you have?
I've been in the hospital.
Okay, I got that. I understand, and that's why I adjourned the proceedings out. But there's about 4,000 that's owed on the judgment. When is that going to be paid? Because the writ, Ms. Lyman, understand, the writ is sitting here in front of me right now. When is it going to be paid? Because I'm assuming if you pay that next week, and if I remember the rental rate, it's about 3,300 or something like that. It's going to go up again. They're just going to begin the case again. I mean, but that's not where I am right now. What day next week are you going to pay this?
Day.
I can't. That's not even next week. That's the week after.
We'll have it until the 8th.
And at that point, they're going to be 4 months, right? Is that right, Counsel?
That is correct, Your Honor.
So then I'm going to be what, 12 plus, well, I'm going to be about 13,000 behind at that point. Simon, I can't continue to do that. I don't mind giving people an opportunity to pay and catch up, but I can't do it. So, you know, the way it works is that I'm signing the writ, I'm issuing the writ, I'm denying the motion to stay the eviction, or I'm not staying the eviction. The writ is signed. If you pay it prior to the execution of the writ, then fine, but otherwise I'm not doing anything else. I can't, in good conscience, do that. So, thank you. Ann's gonna need that. Then, okay, these are all these, yes. So I'm gonna call them all I want. Ram Partners versus Try, Ram Partners versus Brown, Ram Partners versus Robinson, Ram Partners versus Sampson.
Yeah. I still never figured out if those are what the circuit court says on them. I had to go to the circuit court to look that stuff up, but
All right.
I thought we dismissed these.
Well, there I have the dismissals came in late.
Ah, okay, sorry.
All right. Your name?
Monasia Brown. Aisha Sams.
Okay. They have filed dismissals on all of these cases. Do you have a
What is
issue with that?
What's that mean?
That means they're done with me at this point. Their cases are
Can I ask a question?
sure.
Is it
Only the baby can ask a question. I can't hear her. No, go ahead. What?
still gonna be on like my housing record, but like when I try to apply for apartments, it says that I'm.
It shouldn't be. I mean, I don't know because the court's not in charge of those, but if it were there, it should say that the case was dismissed
So,
because they filed the dismissals. Okay,
so we can move out, basically.
you can what? You're looking to move out.
Definitely, yeah.
Okay,
With, they're not gonna fix any of the damages or.
okay. So I don't know how to answer that because I mean, because the only thing I can say is exactly. You look at you. Ah. Oh, I talk to you all day. I don't even like these big people. I was, all right. So I don't know whether or not you could just move out. So I don't want to tell you yes you can because I don't know what the leasing agreement. There's a lot of intricacies in that. Just I would ask the management whether you can move. All right, and the only other issue that I will say about that is part of my concern with these is whether or not these balances are legitimate balances. Because of all of the other litigation and everything that's happened. I don't know. So my worry would be you'd move out, they'd say whatever their claim was in this case, and then try to pursue a money judgment later after you saying you owe this money. That's the part that bothers me. Go ahead.
Money of the rent that they collected from me when the order was in place.
When what order
Non-compliant,
plays?
because that's like $7,000, $6,000. And it's almost the same amount that on there that I owe, nothing against Grand Park, but you know.
Okay, and you bring up a good point. Part of my and why I may be reluctant to dismiss. Because normally I would say just dismiss a case, right? Some of you made payments while there was no certificate of compliance. Then, hold on a second. The circuit court issued a ruling about what should happen in that regard. And I don't know then whether the owners, as you might claim, and I'm not giving legal advice, might indeed owe you money. And that whole analysis might apply to all of it. Whether you move or not, man. Right.
I've been speaking with legal services, and it's a guy named Alex that works there, and basically, he's like the attorney for what's going on with this, and he's just asking for me to send all of my lease documents, all of the signed documents when they agree to getting my money back. So he's gonna be the person to make sure that we get justice for our payments that we made. He was also asking me, you know, like what's going on with the case, just in case he needed to stop anything or jump in.
In these cases,
Yeah, because I told him what was going on right now, and he said that he wanted to stop the process of eviction because of me being a previous tenant at a different unit than being moved. So he's kind of trying to get my rent back from what I originally paid when they were non-compliant.
I wish they'd,
I feel so stuck.
huh?
I said, I feel so stuck.
No, I get you, but I wish if they're gonna give you that advice and you're telling them what's going on, just show up in court and
Yeah.
help the folks out. Hey, it's irritating to me. When are you supposed to talk to him next?
I'm not too sure. He reaches back out whenever he's not busy. I don't know who else he's working with, but he asked for like all of my like legal documents, like my leases and all, any type of paperwork and emails that I had. He said he was gonna, I think he's going through circuit court with that, if I'm not sure.
Well, that's, yes, and that's part of the problem. Part of the problem is these are really Arbor One cases. And hence, certain orders were adhered into. That's kind of what you were talking about, man. And certain things are supposed to happen. So quite frankly, in my mind, even if I dismiss these, that doesn't stop anything from occurring there, right?
It would stop the on our, ledger.
No, I hear you. It would stop, like,
I would just apply for another apartment, move out, and then
no, I know. Yeah, it would stop that. But it also may make it a little bit harder for you. It won't make it harder for you, but well, it will. But you just want an answer.
I just want out.
You want out. You want an answer, and just yeah. I mean that. And if I send you away, it will get resolved, but not.
Correct. Let's just live in the court.
Live in the court? No. Yeah, all right. Did you contact the attorney for Arbor One about this at all?
Yeah, so I talked to Judge Cookie's clerk. He directed me to an attorney in Bodmin. I could read
Right.
her email. She said that people could, this is just from her email, pay rent if they wanted to. Well, say we couldn't try to get the rent from them. That wasn't a very clear answer to me, so first I had to email her twice to get a response. I emailed the prosecutor's office twice, didn't get a response. Got a different email address to the prosecutor's office, still don't have a response to that. I can't look at the court records online unless I go to the court physically, which I did. And it's basically what they said. If I'm not sure if it's their units, but if they don't have a certificate of compliance, they weren't supposed to be collecting rent is my preliminary.
That is exactly it.
I never heard of Alex. I talked to him that.
You did?
No, I didn't know he was involved, so.
Well, legal services is involved, and Alex is the one that has been the attorney on that side. It is unclear what they keep agreeing to on it. It really is just unclear.
Yeah, because, I'm sorry to interrupt you, but it's like they keep saying pay the rent or not, pay the rent or not, but you can't leave. It feels like, that's why I said it feels like we're just stuck.
We can't leave because it's an eviction.
Well, you may be stuck, you may not be. I think the issue becomes. I think it's impossible for you to make a decision until that question's answered, right? I mean, if you're not supposed, if you paid, I have a very different decision to make. If I paid rent when I wasn't supposed to be paying rent and I get money back, because then my the issue of where I move, how I move, what I do becomes very different because it's a whole different financial picture for me. Right? And so, you know what, little one, you just bang away all you want. Don't let those big people tell you can't do that. Don't she can put your feet all up there. This is my furniture. You can put yeah, that's what I'm talking about. Anyway, but folks, here's what I'm going to do. I don't know how it's going to turn out. I'm not dismissing the case. Okay, because I think there needs to be an answer. When you talk to Mr. Henry, do you let Mr. Henry know that these other folks?
You talked to him and said, oh, I'm backlash and Lisa.
He what?
Talked to them already and sent everything over.
Yeah, I don't know if he's just like
So
collecting evidence or going, because he was asking for emails for like the damages of what's wrong with our apartment. And it's a lot of documents that we had to send in.
I did that last year. I did it last year. I don't know.
But he was also asking me if I had other places to go. Resting
Had other places to go?
in case something crazy happens with this, because no one has answered.
And I've been applying, but I'm never even looked.
From this?
That's what I'm saying. I'm unable to leave.
And leave the loans.
Pardon?
Applying for a apartment.
No, I hear.
And then I also had another comment. It's a guy named Roger, I believe. He works for the sheriff's department. And I told him about my situation. And he wants to pay the security deposit for my new apartment, but can't leave. That's like
Okay.
all the help is lined up.
Is there anything you want to say? No. Okay. That's your lawyer. Okay, here's what I'm gonna do, folks. I think everybody needs to look at this again. What I will do so this I will you are something. That's how I sound in the morning. It really is. I'm what'd you say? What'd you say? True? Okay. Okay. I meant at home, not when I got here. But when I get here, that's how I sound. Okay. Wow. I will adjourn out to 2026 at 12 noon. Okay. And I will endeavor to find time this week, folks, to look into some of this myself and try to give you the best answer I can. I know Ms. Hall will continue to do that. And Alex Henry, yeah. So I won't dismiss him. We'll just adjourn him out to that day and see what we can come up with. Okay. I know you want to move, but I don't want you. I want all of you to be in the best position possible. Right? What do you say? You're tired? Me too. All right. Well, little patience. Let's try to get through it because this has just been a mess for everybody, quite frankly. All right. Thank you, folks, for coming down. And you guys have a blessed weekend, please.
Bye-bye.
Bye, baby. What's the baby's name?
Samaria.
Samaria? Okay. I shouldn't be like just calling you baby.
Bye-bye.
Yeah, there were 4 of them.
That's it for us?
Here's all my folders. Good morning. Okay, I found all my folders. Angel just had to show me where to find them. All right, so let's go on the record in the matter of the City of Wyandotte versus Rebecca McKinnon, 26714 A and B, 173143. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Thank you. Ma'am, your name for the record, please.
Rebecca McKinnon.
Okay, and counsel, as to the arraignment.
As the arraignment, we waive formal reading. My client stands mute.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment on both matters, and we will schedule these matters for pretrial. You said June 10th, right? June 10th at 10:45 a.m. And then as to bond counsel.
Your Honor, my client currently
Oh,
is married.
I'm sorry. Excuse me. I'm sorry. Just a moment. I misspoke. The 173143 is the state of Michigan case. So that will have to be June 11th. Can we keep that at 10:45? Yes, and then we have an exam in the afternoon, or at 11, but we should be okay.
10:45.
Okay, so it'll be the same time on June 11th, but it will be June 11th instead of June 10th, based upon it being a state case. Okay, I'm sorry, counsel. As to bond.
Your Honor, my client currently is gainfully employed. She manages 2 smoke shops. She's married and has 2 young children. She's apologetic for not taking care of these matters earlier, Judge, but she assures the court that she will come to any and all court appearances. And she is apologetic, as I indicated, for not managing this better. But at the time, in 2017, her children were very young, and I think that she allowed herself to get very concerned about it, and obviously could have handled this a bit better. But we had a very sincere dialogue, and she's anxious to get this matter put behind her and demonstrate to the court that she could be in full compliance. So we'd respectfully request any leniency as it applies to the bond. She does live in Wyandotte. She is local, and indicates she'll come to court. Thank you, Judge.
Okay, so ma'am, you failed to appear on an OWI second offense. That was a second charge within with less than 3 years. And then you
Yes,
absconded, you've absconded for 9 years now, ma'am.
Yes, Your Honor. I had my daughter, and I guess I was nervous of going into court. I didn't want to go to jail and be not in my young daughter's life. And then my son came along 2 years later, and I kind of just got wrapped up in being a mom. And that's just the truth.
Well, ma'am, not wanting to go to jail, look where you're at right now because you didn't take care of it.
Yes, Your Honor. I do
Doesn't seem to have
understand.
been working out so well. Other than this matter, have you failed to appear in court for any other matters?
No, Your Honor.
Well, let's see. You have a matter from 2024 that you didn't pay on a traffic citation. What's that? Where's that from? 24. Where's that from, ma'am?
I'm trying to think back.
Oh, it looks like Allen Park.
Oh, yes, Your Honor. I do remember that. Yes.
Right. You didn't make your payment. And so you're suspended.
Yes, my
It
license
was from
has
an,
been.
it was from an accident for careless, negligent driving. I'm sorry, what were you saying?
I thought it was only for a suspended license, and I was calling to make arrangements to pay them. And my mom felt ill at the time. So it just all around just bad luck, to be honest.
Well, ma'am, it's not bad luck. It's intentional choices that you're making to operate a motor vehicle without a valid license. That's not bad
Yes.
luck. There may be other life happenings. There may be other life happenings that are occurring, but that doesn't mean that everything else stops.
Correct.
Especially not for 9 years. And then you know that your license is suspended and you're arrested for driving on a suspended license again.
Yes, I do understand.
Right. Well, ma'am, how old are your children now?
7 and 5. My son just turned 5 yesterday, and we were supposed to be having his party Sunday.
Well, ma'am, I'm sorry. You indicated that you had your daughter, and that's why you didn't come to court and take care of it because you were afraid to go to jail. But this is 9 years ago, and your oldest child is 7. So what happened for those 2 years?
I got pregnant shortly after that. I didn't have a court date until like 3 or 4 months after. And that's when I shortly found out I was pregnant. And then the court date came into play, and I didn't show up because I was pregnant.
Okay, well, that is not really making numerical sense with how the time you were arrested August of 17, and you had your child in 2019.
Correct.
Okay, so presumably May or June. So in almost 2 years, you're telling me you were pregnant for almost 2 years?
No, it was about 6 months after the fact of me getting pulled over for that incident. I was pregnant. So I started to show up for the court date, the first one, and then after that I just did not go after that. I believe they wanted like a drug test or something along those lines, and I became pregnant and just didn't show.
Well, I can tell you, you were supposed to have been in court September 5th of 2017, so that wasn't 4 months later. So I'm not really sure what it is you're speaking of, ma'am. But your notice was sent August 22nd of 2017 to appear September 5th of 2017. And you clearly were not pregnant at that time based upon when your daughter was born. So,
No.
So based upon some of this lack of accurate information this court has, I don't have much confidence that you're going to be appearing in court on your own. What this court's going to do, in addition to making sure you're going to appear in court on your own with this court order, the court's going to, and to ensure the protection of the public, the court's going to order on the 173143 a $5,000 10% bond. On the 26714A, the court's going to order a $500 cash bond. With the following bond conditions: you are not to be released without a GPS and alcohol tether from the Wayne County Jail. You are not to possess or consume any alcohol or drugs that are not prescribed. And you're not to operate a motor vehicle, ma'am. Is your current address the one on Goddard Street?
Yes, that's correct.
We want to make sure we change this other one that we have. Okay, we'll see you back on June 10th and 11th. Thank you. All right, we are on the record in the matter of the city. Actually, let's go off the record for just one moment. Let me just put this attorney in breakout room. Oh no, that's a different matter. Okay. Let's go back on the record in the matter of the city of Wyandotte versus Casiano Roberts, 26713. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom.
Thank you. Ma'am, your name for the record, please.
Can we be done?
Your name for
Oh.
the record.
Kashana Roberts.
All right, and so counsel, as to the arraignment.
Wait, formal reading. My client stands mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, schedule this matter for pretrial on June 10th at 10:45 a.m. And counsel as to bond.
Your Honor, my client currently is not on probation or parole. To my knowledge, she has no priors. She does have a daughter. She has strong family support in Dearborn Heights. She was working at Amazon, but is now looking for new employment. I know financially she has limited means, so I'm going to ask for leniency in consideration for a personal bond. Thank you, Judge.
All right, and who do you reside with, ma'am?
Who I stay with?
Yes.
Well, I guess you can say I'm staying with my mom. I'm house hopping at the time.
And how long has it been since you have worked, ma'am?
Since the end of January. But I do Amazon, I do Instacart and DoorDash on the side. In the meantime, until I can find.
Do you have any other matters that are pending?
What does that mean?
Do you have any other court cases that are pending right now, ma'am?
Not that I know of, no.
If you were to test today, what would be detected in your system?
Probably just the alcohol.
Anything else?
And marijuana.
When's the last time you used marijuana, ma'am?
Was a day ago.
Okay. The allegations are pretty high level, ma'am. Have you ever failed to appear in court for any reason?
Not intentionally, no. Never.
All right. The court is going to order taking all these matters into consideration, the court's going to order a $250 cash bond. You're not to possess or consume any alcohol or drugs unless prescribed. We'll see you back on June 10th. Thank you. Have a good day.
Thank you, Your Honor. Have a good day.
Thank you, Judge.
All right. Thank you. Okay, let's go off the record.
All right, Ms. Miles, good morning. You are Sally Ann Miles. Your date of birth is October 31st, 1962. Is that correct?
Yes.
Thank you, Ms. Miles. There are a number of matters that are before the court this morning following service of bench warrants. Case number 25L000030 is before the court for sentencing following a conviction after jury trial. There is also 25L000068, which is before the court for a 11th pretrial conference. 25L004090 is before the court for a 7th pretrial conference. 25L004459 is before the court for a 5th pretrial conference. 25L004746 is before the court for a 3rd pretrial conference. 25L004967 is also before the court for a 3rd pretrial conference, as is 25L004980. and 25L005135. There is also two new charges that are before the court for arraignment this morning. 000505 on a charge of anti-harassment protection order violation with an alleged incident date of April 6, 2026. And also an arraignment matter before the court under 26L000663, also for a charge of anti-harassment protection order violation with a alleged incident date of May 10th, 2026. Ms. Miles is represented by counsel on, let's see here, 1, 2, 3, 4, 5, 6, 7, 8. 8 of the 10 matters, Mr. Williams. It appears that your colleague, Mr. Nemec, is the attorney of record. However, oh, no problem, no problem.
That's correct. Just scanning. Which two cases?
Not believe that our office represents him on.
Yeah, that was the next thing that I was going to indicate. So it appears that the sentencing matter, which is the oldest of the 10 cases, that's 25L000030. That matter, it appears Ms. Miles is currently unrepresented. And then also on the newest case, ending in 0663, it appears Ms. Miles is unrepresented. So the oldest case, which is before the court for sentencing, the newest case, which is before the court for arraignment, it appears Ms. Miles is not, or the court has not received a notice of appearance from counsel. But the other 8 matters, the court has received notice of appearance and granted substitution of counsel by Mr. Nemec.
Understood. And I believe Miss London is here for Miss Miles as appellate counsel for the one that's awaiting sentencing. I don't know the scope of her representation in terms of whether she represents her for any sentencing proceeding. I was less clear on the 2 cases that are here for arraignment. Appreciate that our office has filed a notice of appearance on one. I'm happy to stand in as a friend of the court for the other case that's here for an arraignment as well. And I'll leave that to Mr. Nemec to address down the road in terms of representation.
Okay, so that sounds like a good plan because I do want to proceed with those 2 arraignments just for purposes of housekeeping, if nothing else. I'd like to get those 2 matters arraigned. So, Ms. Tuininga, is there any objection from the prosecution to Mr. Williams standing in on the newest arraignment matter, even though Mr. Nemec and frankly no attorney has filed a notice of appearance on that matter to date?
No objection, Your Honor.
All right, so let's go ahead and proceed with the 2 arraignment matters. Ms. Miles, just by way of trying to keep the record as clear as possible, you are before the court for 2 arraignment matters in addition to the other 8 cases this morning. The 2 arraignment matters are 26L000505. In that matter, the city of Lakewood has filed a criminal complaint charging you with 1 count of anti-harassment protection order violation, which the city of Lakewood alleges occurred on or about April 6th, 2026. In that matter, the court has received a notice of appearance from attorney Kyle Nemec as attorney of record, which I understand is Mr. Williams, one of Mr. Williams' colleagues in the same firm. There is also an arraignment matter scheduled before the court this morning in 26L000663. The city of Lakewood has filed a criminal complaint in that matter, charging you with 1 count of anti-harassment protection order violation, which they allege occurred on or about May 10th, 2026. Mr. Williams, at this time, are you prepared to proceed in representing Ms. Miles for purposes of the arraignment hearing?
Yes, Judge, thank you. I did have a chance to review the charging documents in both cases, including the accompanying police reports that were provided, I assume, for probable cause purposes, would waive a formal reading and enter a not guilty plea. It would stipulate to probable cause as well for purposes of today's hearing only.
All right, thank you. So the court will waive formal reading of both of these criminal complaints for purposes of today's arraignment hearing. The court will accept the defense's stipulation to probable cause as well for purposes of today's arraignment hearings. And the courts will enter pleas of not guilty to each of those two counts at this time. Now that kind of places the next issue squarely before the court, frankly, in all 10 cases, Ms. Tuanenga, and that is conditions of release on the 9 matters that are now in pretrial status, as well as the 10th matter that is before the court for sentencing. And I do, before I hear from the prosecution, I do want to give the other counsel who is online on the Zoom platform on behalf of Ms. Miles. I'd like to give her an opportunity to make her appearance. So counsel, if you would like to go ahead and make your appearance at this time.
Thank you, Your Honor. Good morning. Diana Lundeen. I am appearing as a friend of the court and as sort of a standby to assist the court in regards to the matter that's on for sentencing. I have recently been retained by Ms. Miles to represent her in the Pierce County Superior Court in that matter. And I'm happy to provide the court with an update about the appeal. I'm still trying to ascertain the entirety of the procedural history, but I do understand that the sentencing had previously been stayed and the appeal has been pending for some time. So I'm happy to provide the court with any information it wishes in that regard. I have not been retained to represent Ms. Miles in regards to sentencing, and I'm ill-equipped with the details of the facts of the case to be able to do that. It's certainly not today. And I was out of town when Ms. Miles was taken into custody, so I have not had any direct communication with her. I'm simply here to advise the court as best I can and take whatever steps would be helpful.
Ms. Lundeen, thank you very much for that. And I do see that you have filed a notice of appearance on the appeal matter following the jury trial conviction in case ending in 0030. That is now on file. I did review the links filings, I believe, yesterday, and I did see that you filed as an attorney of record. It looks like that matter is pending before Judge Penalver with a hearing, I believe, scheduled in September. I will tell all of the parties at this point in time, my inclination is not to take any action on the sentencing today for a couple of reasons. And number one, and most importantly to me, Ms. Miles, as a matter of record, is not represented in that matter. Ms. Lundeen has filed a notice of appearance to appear as appellate counsel on the Roush appeal in Pierce County Superior Court, but there is no notice of appearance in case number ending in 0030 in this court. Presently, Ms. Miles is unrepresented. That was actually one of the things that I was hoping Ms. Lundeen and or Mr. Williams or Mr. Nimick could address, whether or not there's a plan for either Ms. Lundeen, who is representing Ms. Miles on the appeal, to also file a notice of appearance in this court on the matter that is pending sentencing, which is the product or the what has produced the need for the appeal, or if Mr. Williams, Mr. Nimick is planning on coming on that matter as well. Can either Mr. Williams or Ms. Lundeen speak to what the plan is for that, if there is a plan at this time?
Your Honor, I can say that to the best of my knowledge, there is not a plan that involves me at this time. I have recently been retained by Ms. Miles. I am unfamiliar with the entire record. In fact, just to let the court know in terms of the status of the appeal, it appears that it was sort of tracking along with these other matters, and maybe the parties were hoping to settle them and it wasn't going to be pursued immediately. So it's basically starting from the beginning. I've just requested the audio recordings from the court yesterday. There's not been any transcription. That's why the status hearing has been rescheduled to September. So I do understand from Ms. Miles that she wishes for me to pursue the appeal diligently, and I will do so as quickly as I can. But I am not in a position to have a full understanding of the history of all the facts of the case and the circumstances that resulted in the conviction. So I have not been retained to represent her. It was my understanding when I was retained that the sentencing had been stayed, which it was. If there's a change in circumstances, I would certainly need to have that conversation with Ms. Miles and go from there. But I would be unprepared to do anything meaningful within the next little bit here. I do want to just alert the court, though, that I may need to file at least a limited notice of appearance in the Lakewood Municipal Court on the 3-0 matter because it appears that there was a designated record, but I don't know that it's complete. And if I need to request additional materials, I may have to enter a limited notice of appearance for that purpose. I don't want the court to confuse that with a notice of appearance in total for that matter, including sentencing, until I've been retained to do so by Ms. Miles. So I hope that clears that up.
It does, and I appreciate that record. I will tell you, Ms. Lundin, everything that you've indicated to the court, I believe is correct and is consistent with my recollection, except for one thing. I do not specifically remember an order from the Superior Court or this court making a ruling on a motion to stay sentencing. What I do recall is Ms. Miles' prior counsel, Mr. McGowan, asking the court to refrain from proceeding with sentencing in the hopes that a global resolution could be reached and negotiated by the parties. And previously there's been, and I'll let Ms. Tuninga correct me if I'm wrong, but previously the request to continue sentencing was essentially agreed by the parties. The parties both agreed that yes, negotiations are ongoing, so we're not asking the court to proceed to sentencing. Now, Mr. McGowan has since withdrawn on every case, and Mr. Nemec has filed notice of appearance on virtually every other case except for the sentencing matter. So procedurally, that is kind of where we are. Let me ask Mr. Williams at this point, and then Ms. Tuninga, I'm going to give you an opportunity to weigh in. Mr. Williams, do you know, does Mr. Nemec plan to file a notice of appearance on case number ending in 0030 that is pending sentencing, but is also on appeal in Superior Court?
I don't have any information in that regard. I will encourage Mr. Nemec to have that conversation with Ms. Miles. It may make some sense in terms of the intertwined nature of all these cases, but ultimately that's going to be a decision for her to make.
Understood. Okay. So I will tell all of the parties again. Well, actually, before I say anything further, let me give Ms. Tuning an opportunity. Ms. Tuning, anything you'd like to add to the record that's been made concerning case number 0030 that is scheduled before the court for sentencing?
Your Honor is correct in the fact that when I was working with Mr. McGowan, we did set the sentencing over a number of times in an effort to achieve a global resolution. It was unfortunately late April when unfortunately the global resolution fell apart, which is what led to the warrants that we now see Ms. Miles in custody before the court. I have had a phone call with Ms. Lundin. I have never communicated with her for the purposes of sentencing. I have included my sentencing recommendations to Mr. Nemec out of a sort of kindness recommendation. I had frankly forgotten that he was not attorney of record on that case. So not that I'm insisting that that firm take up that obligation, but just making sure parties are aware of basically where things are set. And Ms. Lundin had introduced herself as strictly the attorney for the appeal. That was what I understood her scope to be limited to. If it is not Your Honor's intention to be moving forward with sentencing today, I do have I do have Miss Miller here present. Would Your Honor like to hear her statement today, or can we excuse them?
Before we excuse them, I guess I'd like to figure out what we're going to be doing with the other 9 cases concerning conditions of release. I will tell you that I am reluctant to move forward with a sentencing on a case where the defendant is not represented by counsel.
I understand your concerns, Your Honor. I am not generally here on Wednesdays or Fridays, which are the in custody docket. I just saw it was a unique combination of circumstances that Miss Miles was in custody. I happened to be covering this Friday. And I knew I could get Miss Miller here this Friday. So if it is to be set over, this unique circumstance might not appear again. I just want to make sure that I protect Miss Miller's time, and I'm able to not overexert Mr. Vinson by bringing him up to speed on everything in this rather large number of cases.
Sure, and I appreciate that. I do want to give the Millers an opportunity to make any statement that they would like the court to consider for purposes of pretrial conditions of release on the 9 matters, as well as the conditions of release on the sentencing matters. But first, before I hear from them, what is the prosecution's position concerning conditions of release on the 9 matters that are in pretrial conference status, and also the matter that is before the court for sentencing?
Your Honor, my recommendation is exactly the same I requested for back in April, based on the history of violations of this order, based on my conversations with Ms. Miller, of the defendant's continuing almost malicious non-compliance with this order. The city is requesting bail of $50,000 on every single charge, conditions to abide by the order, which the defendant is wholly incapable of doing, and for the defendant to have no criminal law violations.
Okay, and so previously, and I'm looking back at the docket, if I remember correctly, the motion that was made by the prosecution on April 27th, 2026, following the most recent failure to appear by Ms. Miles, and there's more than one.
That was a mistake. I just was confused on the dates. I'm really sorry.
Ms. Miles, will you just hang tight, please?
Okay.
Thank you.
That was on April 27th, 2026. At that time, Ms. Tuaniga, you brought a motion for bench warrants on 8 of these 10 matters because the 9th and 10th matter had not yet been arraigned, is my recollection. Is that correct?
I think it was 9. I think one of the arraignments had been filed, but the other arraignment had yet to be filed.
Okay, you may be right. Okay, and so the court granted, yeah, you are right. I'm taking a look back at that. So yeah, 9 of the case number ending in 0505, that matter had been scheduled for arraignment that day. And so that was one of the failures to appear. So there were 9 matters where the court found a failure to appear and granted the prosecution's request for bail in the amount of $50,000 cash or bond on each of those 9 cause numbers. Total warrant amount was $450,000 cash or bond, and that warrant was served. You're asking that bail amount remain. Is that correct?
Yes, Your Honor.
Are you seeking any additional bail on the new matter, case number ending in 0663, that the court conducted arraignment on earlier today?
Yes, Your Honor. I'm seeking the same amount of bail that I am on every other case, $50,000.
All right, so you're asking for a total of $500,000 cash or bond?
Yes, Your Honor.
Any other conditions that you're asking to be heard regarding?
Just that the defendant abide by all active no contact orders.
Mr. Williams?
Thank you, Judge. I appreciate the court sets a certain bail amount when it issues a warrant. And I assume that's in part designed to ensure that the defendant comes before the court before making bail after the court having issued a warrant. I don't know that the $50,000 amount that's attached to each warrant should necessarily be the benchmark by which the court sets conditions of release. The court did, near as I could tell, the court set bail at roughly 10,000 a case prior to, I think when she failed to appear back in April, she had a bond in place of $95,000 that was exonerated bonded by the bonding company. So if there were 8 cases, and I'm not clear if there was 10, which amount went with which, but if there were 8 cases at the time with a bond amount of about $95,000, I'm guessing the bail was somewhere in the amount of $12,000 per case. That's what I would ask the court to do, is set bail. She's got now 10 cases. I'd ask the court to set bail in the amount of $120,000 cash or bond, which would be consistent with the court's prior rulings. I haven't heard anything as it relates to criminal history. I would just point out that under 3.2, there is a presumption of release. I appreciate that she failed to appear back in April. There's no allegations in terms of tampering with witnesses, no allegations of violence. I appreciate that the allegations are concerning. I truly do. And that she's not following court orders. But the focus, it would seem to me, should be on ensuring that this woman comes back in the future. And so a bail at the amount of $120,000, I believe, would give her every reason to come back to court moving forward. That's what I'd ask the court to do. I would just note that regardless of the bail that's imposed, Mr. Nemec's request is to set this over 2 weeks to allow him to adequately prepare for her. So I know we're going to address dates next, but that'd be our proposal. Thank you, Judge.
Thank you, Mr. Williams. I want to be respectful of the fact that the Millers are here. And so if the Millers would like to be heard on do either Mr. or Mrs. Miller, the alleged victims in all 10 of these cases, wish to be heard by the court at this time, Ms. Tuninga?
Yes, Your Honor, yes.
Okay, so Mrs. Miller, I'm going to ask that the microphone be clearly in front of you, that you speak clearly into the microphone. It's very important that the individuals who are present in the courtroom, as well as the individuals who are on Zoom, as well as the record that is being made, accurately capture your sentiment and your statement, okay? And I'm going to begin by asking you to please identify yourself by stating your full legal name for the record.
I'm Kimberly Lee Miller.
Ms. Miller, what would you like the court to know concerning pretrial conditions of release in these matters?
Well, Your Honor and counsel, we are sad and disappointed to find ourselves in this courtroom this morning, having to speak of some of the most hurtful, unfair, unwarranted acts of hate and retaliation against us at the hands of Ms. Miles. Since September of 2022, we have endured ongoing pattern of relentless harassment, intimidation, false reporting, retaliation, and stalking type behavior by Ms. Miles. What began with our first protection order in district court in 2023 has continued through 2026 with the current protection order that was issued by Superior Court. Even now, Ms. Miles continues to verbally attack us, make obscene gestures, surveil us with cameras and cell phones, and deliberately monitor and document our daily activities despite being repeatedly warned by both the court and her own attorneys to cease contact and surveillance. As recently as this past Sunday, Ms. Miles verbally confronted me while I was walking my dog using profanity and degrading language. And then only hours later, she stood watching me while I pressure washed our boat trailer before retrieving a camera and positioning it to record me from her back gate. Unfortunately, this has become our normal reality. We live in constant state of vigilance, wondering where she might be watching, what she might be recording, and what allegations she may fabricate next. We fear she may hurt one or both of us eventually. Over the years, Ms. Miles has weaponized government agencies and the legal system against us through repeated false allegations and retaliatory complaints. Thank you. Sorry.
Don't apologize. Take your time.
She has made numerous false reports to 911, to the Lakewood Police Department, the Liquid 311 app, municipal agencies, adult protective services, and even the FBI. APS has investigated us 5 separate times, and every time, every report was determined to be unsubstantiated. The FBI also investigated us. Allegations she made against us, and again, no wrongdoing was found. She has filed multiple petitions against us in Superior Court, all of which were denied, with the court finding Ms. Miles to be not credible and retaliatory. In several cases, the court awarded us CR 11 sanctions and attorney fees in our favor due to the vexatious and frivolous nature of the filings. Despite these judgments, Ms. Miles has failed to comply with the court's orders and has failed to reimburse us for our judgment. What has been most disturbing to us is the complete disregard Ms. Miles has shown toward the authority of this court, Superior Court, law enforcement, and the judicial system as a whole. She openly refers to the protection order as fraudulent, and she continues violating it with little concern for consequences. This court is only aware of a fraction of what we've experienced. The harassment has included verbal abuse, obscene gestures, property damage and interference, repeated false allegations, degradation of our family members, intimidation tactics, manually sounding security camera alarms and vehicle alarms as we pass out our driveway, and disturbing behavior directed towards elderly family members and our animals in our care. Ms. Miles repeatedly called 911 claiming that we brandish firearms and threaten her with guns. Allegations that are entirely fabricated. She has never once witnessed us threaten or display a firearm towards her. These accusations appear to stem from a photograph she found on my Facebook page. The picture shows me legally carrying my holstered firearm while fishing in a remote wilderness area. From that single image, she constructed an increasingly extreme allegations involving legal weapons and alleged conspiracies with the United States Post Office, and reported to the FBI. And in 2023, she was actually ordered by Judge Williams not to interfere in our mail delivery service, which she continues to do to this day, this very day. The abundance of vexatious and false reporting alone has been devastating. It's wasted public resources, triggered investigations, damaged our peace of mind, reputation, and forced us to repeatedly defend ourselves against completely baseless accusations. Sorry. The emotional and psychological toll and the financial impact has been enormous. Our lives have changed dramatically over the last 4 years. We continue to fear for our safety, despite having done everything asked of us by pertinent municipalities and law enforcement agencies and officers. My husband has even suggested on more than one occasion that we sell our home and relocate, believing that life is too short to endure this ongoing stress, fear, and disruption we have experienced. However, my home has been in my family for 4 generations and holds deep personal and historical significance to us. It would be of profound injustice for us to feel compelled to abandon our home, our roots, and our sense of security because of the continued conduct of Sally Miles. No family should be forced from their home as a result of another person's harassment and disregard for the law. We've had to install security cameras not to invade anybody's privacy, but because we have had no choice but to protect ourselves, our property, our animals, and ironically, while she's accusing us of surveillance, Ms. Miles herself maintains multiple cameras aimed towards neighboring properties and has submitted multiple recordings of us using and maintaining our driveway easement in attempts to have us prosecuted. We've missed family events, social gatherings, travel plans, and irreplaceable time with loved ones due to the constant court appearances, investigations, and stress caused by this situation. During much of this ordeal, I was also caring for my 87-year-old father as he battled terminal stage 4 cancer. And no family should have to endure this level of sustained harassment while simultaneously navigating serious personal hardships. For 4 years, we've attempted to show Miss Miles grace, hope, and hoped counseling and intervention might help resolve this situation peacefully. Even after repeated violations, we did not report every incident because we just hoped her behavior would stop. But instead it has only escalated. Ms. Miles was offered many opportunities for leniency and resolution, yet she chose to proceed to trial, in this case 0030, ending in 0030, resulting in a jury of her peers finding her guilty within minutes. Even after conviction, Sally continues to deny responsibility, appealing the verdict, blaming others, and refuses accountability for her actions. Your Honor, accountability matters. At some point, reported harassment, false reporting, court order violations, failure to appear in court, the abuse of the legal system must carry meaningful consequences. Without consequences, this behavior simply continues, and Ms. Miles has clearly demonstrated that her behavior, she has demonstrated to this court, as we are on, this is hearing number 30 today. We respectfully ask this court to impose a maximum sentence that reflects the seriousness, duration, and ongoing nature of Ms. Miles' conduct. We ask not out of revenge, but out of exhaustion and fear, the hope that our family may finally have some peace and safety in our own home again. Thank you, Your Honor. Respectfully, Jason and Kimber Miller.
Thank you, Mrs. Miller. So, Ms. Tuaninga, I did have one question for you. If you have any information, and I don't know if you do or not, the warrants in these matters, in 9 of the 10 matters, were issued on April 26th. Do you know how it was that these warrants were finally served?
Yes, Your Honor. It's my understanding that officers were able to, they arrived at Ms. Miles' residence. Officers announced over the loudspeaker for Ms. Miles to come out of the house to avoid damage to Ms. Miles' front door. Eventually, they found an open window and were able to serve the warrant without having to enter Ms. Miles' front door.
Okay, so Ms. Miles was within her residence at that
Yes, Your Honor.
Okay. Well, the court certainly understands the argument that Mr. Williams is making on behalf of Ms. Miles, and it does have credence. First of all, Ms. Miles is entitled to the presumption of personal recognizance release unless the court reaches a point where it believes that one of the 3 factors, that likely to commit a violent act, likely to fail to appear for future proceedings, or likely a threat to the administration of justice, has been established by the prosecution. Previously, the court has imposed bail in the amount of $10,000 cash or bond on pending cases in Ms. Miles' matters. The total bond amount, I think Mr. Williams is correct, I think it was right around $90,000. Since that time, additional cases have been added because additional charges have been filed. What is of concern to the court is that even though that bond was in place, it was insufficient to produce Ms. Miles' appearance at proceedings as ordered by the court. And that is what led to the issuance of additional bench warrants and frankly, an amount that is exceptionally large for this court. It's very unusual for this court to issue warrants that aggregate to that monetary value. The court is concerned with Ms. Miles' warrant history among these 9 cause numbers, that there is a likelihood of failure to appear. So that is one concern this court has. The court is also concerned that just looking at the incident dates that are alleged, and there are only allegations at this point, Ms. Miles is presumed innocent on 9 of these 10 matters. On the 10th matter, 0030, a jury has found beyond a reasonable doubt that she's guilty. And that is the matter that she is pending sentencing on, and that matter is on appeal. But in 9 of the 10 matters, she is presumed innocent. However, the court can't ignore that there has been additional filing after additional filing after additional filing where the court has found, either by stipulation or review of the probable cause statement, that there is probable cause to believe that Ms. Miles continues to, at this point, systematically violate the no contact order that was previously issued by the Pierce County District Court, and now it has been issued by the Pierce County Superior Court. The court is at a point now where I have zero confidence that Ms. Miles will appear as ordered by the court, zero confidence that Ms. Miles will comply with this court's order or the orders of the district and superior court. And so at this point in time, I'm going to grant Ms. Tuaninga's request. I'm going to impose bail on each of these 10 cause numbers in the amount of $50,000 cash or bond, for a total bail amount of $500,000 cash or bond. Now, the court at this point is going to need to discuss scheduling. It gets tricky because we have a sentencing matter, as I've mentioned before, where Ms. Miles is not presently represented. It sounds as if Ms. Lundeen is not going to be filing a notice of appearance for purposes of substantive representation in the sentencing matter in this court. And I certainly understand she is representing Ms. Miles in Superior Court on the appeal. And it sounds like Mr. Williams is going to have a conversation with Mr. Nimick about whether or not their firm is going to be coming on that sentencing matter as well. But we're going to need to schedule that matter as well. My inclination is just to keep that sentencing hearing tracking along with the 9 pretrial conference matters. I also want the parties to be aware, it's not lost on me, and I don't know whether or not Ms. Miles is going to post bond or not, but as long as she is in custody, this case is going to be a priority for the court to move forward on. And frankly, even if she's out of custody, given that we are now at a point where we have 9 pending charges, the court is going to want to start moving forward in these 9 pending matters. I don't know if the prosecution has a position on whether or not to continue sentencing at 0030. And frankly, I don't know that we need to address that today, because I'd like to resolve the issue first of whether or not Ms. Miles is going to be represented in that matter, and if so, by whom, before we talk about scheduling and sentencing, or whether or not we're going to be proceeding with sentencing. And obviously, I want to give Ms. Lundeen an opportunity to weigh in on that as well, since she's handling the appeal. But at this point, I guess the question that I have for the attorneys is, I'd like to set these 9 matters for pretrial conference with the sentencing matter tracking. And I would like to set the pretrial conference in about 2 weeks, I think is what was suggested by Mr. Williams. Is there any objection to setting this matter on the in custody Nisqually calendar for, let's see, today is the 29th. Let's go ahead and set this for Friday, June 12th at 11 a.m. Is there any objection to that from either party?
I could just have a minute to look at Mr. Nimick's calendar.
Oh, absolutely.
And Your Honor, I'm not typically the person who appears on in-custody calendars, and I do know this is a quick turnaround, but I'm having to fight against Lakewood's once-a-month trial. If parties are unable to come to a resolution on June 12th, and we set this for readiness. Could we set this for readiness on June 19th? I see there's something on the calendar, but I can't quite make out what that is at this distance.
June 19th is a holiday. June 18th is the readiness calendar for the June trial date.
I'd be presuming this would be in custody.
Can I briefly address that? So she has a right to speedy trial within 60 days of today. So I'm not asking for the court to make any kind of good cause finding today, and I don't have a speedy trial waiver from Ms. Miles. My suggestion is we set pre-trials in 2 weeks, as the court has indicated, tracking along the sentencing case. In 2 weeks, I would expect Mr. Nemec to have a much better idea about trial readiness, resolution. I don't know that we need to set a readiness today, though.
That tends to make sense to me, Ms. Tuaninga. I mean, I understand the position that you're in. It may very well require you to either appear as you did today or to communicate with whoever will be appearing on behalf of the prosecution at 11 a.m. on Friday, June 12th.
I would anticipate appearing on June 12th regardless. My issue is the turnaround is if it's set for pre-trial on the 12th, I don't want to lose the June trial term. Because if it's set for, if speedy starts now, I essentially have the June trial term and the July trial term before I run out of speedy. And that's only enough time to bring 2 of these cases to trial, assuming lack of joinder.
Sure.
So
the court does have mechanisms available to it to continue matters and to continue the speedy trial. I certainly don't expect that the parties would be trying, all 9 of these matters simultaneously during the same trial term. That is not the expectation this court is going to have. And obviously the court will need to hear whatever motions either party wants to make, and the court will rule on those motions accordingly. I do understand the concern that you're raising, but I do think that given the number of cases, given the fact that Mr. Nemec is still relatively new to these cases, I'm loath to put him in a position where he has to come before the court for a pretrial conference in less than 2 weeks.
Yeah, and I don't want to begrudge defense, but I just think the timeline's pretty tight.
It is. Yeah, you're absolutely right. When we're talking about the 60-day in custody pretrial conference block, you're absolutely right. So that's what we're going to do at this point. We're going to go ahead and set the matters for pretrial on Friday, June 12th at 11 a.m. We'll see where the parties are at that point in time. Now, in the event that Ms. Miles is not in custody, if she posts bond, are the parties wanting to keep that as an out of custody hearing time as well? Or should we set a different out of custody pretrial conference date?
As long as the court is willing to address her matter, whether she's in or out in 2 weeks, I would just suggest 1 day.
That makes sense to me if that's all right with the prosecution. That's not our normal practice, but for this particular case, I think that makes sense.
And just out of defense to defense, would Ms. Miles, assuming she's out of custody, be permitted to appear via Zoom, because she obviously wouldn't be permitted?
No. So, and I'm very grateful that you brought that up. The court with prior counsel, Mr. McGowan, made clear to counsel and to Ms. Miles, and I can go back and find the date, I think it was in like February or March, that because of issues with failure to appear, as well as issues of ongoing allegations of violations of pretrial conditions of release, the court rescinded the authorization to appear under 3.4 and required that for every hearing, Ms. Miles had to be physically present with counsel. The court is not entertaining 3.4 appearances in any of these matters.
Okay, I just wanted to lay out the mechanism. So supposing she bails out, we're keeping the June 12th court date, but she will need to be here physically.
She will need to be physically present in person and on time for all scheduled hearings if she is out of custody. If she's in custody, officers will produce her. But if she is out of custody, it is her responsibility to be here in person and on time.
Okay, thank you, Your Honor.
You're welcome. And Chanel, the order that I'm looking at, the pretrial release order, it does not list 0030. Is there a way to add that to, so it's all one order? Do you mind? Do you mind? Yeah, that would be great.
And Your Honor, for what it's worth, I'll just let the court know that I'm actually in a conference on June 12th. So I don't anticipate that I'd be making another appearance, but in the event that Ms. Miles decides that that's the route she wants to go, I just want to notify the court right now that I cannot be there on that day.
Okay, and I appreciate that, Ms. Lundeen. Thank you. I guess what I would ask is that you remain in communication with Mr. Nimick.
Absolutely.
And if something comes up where we need to reschedule that pretrial conference so that you have an opportunity to be present as well, we can cross that bridge when we get to it.
Fair enough, Your Honor. I just wanted to alert the court. Thank you.
Thank you. All right, thank you all for your patience. The court has signed that order. Ms. Miles, that will conclude your hearing. You can go ahead and let the officer know that your hearing is done. We will see you back here in 2 weeks on June 12th at 11 a.m., okay? Thank you. Mr. Williams, thank you very much.
Hey, Judge.
Mr. Williams, can I talk to you before?
Miss Miles, I'm gonna let Mr. Nemec know to reach out to you. You should expect him to be meeting with you next week, okay?
Okay, I really need to talk to somebody today.
I will impress upon him the need to do that, okay?
Okay, thank you.
Okay, take care, ma'am.
Dispute Resolution Center let me know that Bailey and Wohl are ready. Is that right?
That is correct.
And that's number 39522. Okay, so let's see. I've got you both here on the line. All right. I'm going to explain to you real quick how these trials go. So what I'll do is I'll swear both of you in, and then the plaintiff will get to go first. The plaintiff will tell me their case first. That means your testimony, reference to any exhibits that have been properly filed in the case. If there are any witnesses you have you'd like to testify, I can swear them in and hear from them as well. After the plaintiff has had their opportunity to present their case, then I'll hear from the defendant. That's Mr. Wohl in this case. And it's the same thing. I'll hear testimony. You can refer to any exhibits. And if you have witnesses who you brought with you, I'd swear them in and hear from them as well. After I've heard from each side one time, then I'll make a decision. I'll let you know what that decision is and the reasons for it so that you know that I'm following the law in your case. I'm going to ask you to follow a couple of rules. One is when the other party is presenting their side of the case, please don't interrupt them. Just let them tell me their side of the case. Even if you believe that that other party is telling me something that's incorrect, misrepresenting, whatever, just please let them tell their side of the case. Keep in mind that you will be able to tell me your side of it in a few minutes, or you have already told me your side of it. So I expect maybe to hear some different things, and that's okay. I may need to interrupt and ask you questions from time to time. And the reason that I would do that is just to make sure that I understand your claim or I understand your defense to the claim. And I may do that just to kind of keep the focus in the case on the facts and circumstances that are going to help me resolve the case, and maybe not on some extraneous facts that won't. So with that in mind, I'm going to ask both of you, Mr. Bailey and Mr. Wohl, to raise your right hands, please. And do you each swear the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
I do. Yes, Your Honor.
Okay. All right, Mr. Bailey, you're the plaintiff. Go ahead, sir.
Thank you. Good morning. My small claims case is to recoup the amount of money that Ryan owes for shared utilities in our shared living spaces. We've lived in 2 different residences, and I've kept a ledger from the previous house to his former current place now, where I'm still at. I ran a ledger regarding what bills came in and what those bills were cut in half to reflect what his responsibility was towards these utilities for Puget Sound Energy and the city of Olympia for water, sewer, and garbage. Those bills were in my name. Ryan had Xfinity or Wi-Fi, that was his bill. So I would document on the monthly utilities that were charged towards us, and also document the fact that Ryan had paid the Wi-Fi bill, which was around $98. And so I would deduct that from the ledger from money that he had already owed to me regarding the shared utilities. The original claim that I had stated before the amendment was the amount of $1,350. When Ryan gave me 7 days notice to move out at the end of March, I then went to, I talked to my landlord and asked him if he'd heard from Ryan, and Ryan had not contacted the landlord regarding his departure without 30 days notice. The landlord at the time stated that that he forfeited his share of the deposit because of the lack of due process on his end for 30 days notice. So I looked at the lease to find out just the particulars of the lease. The lease states that if there are any cleanup or damages that are due upon the departure of a resident, that the landlord would charge $50 an hour for cleanup and or disposal. So my amended claim reflected the 5 hours at $50 an hour for the cleanup and disposal of his belongings that he left behind, and the fact that he didn't clean up. And so the amended amount due was $1,448. And that's what I believe is his responsibility for the shared utilities while we had lived together in two different rentals.
All right, Mr. Wolfa,
Yes, Your Honor.
your response?
So first of all, like I explained to the mediator before we came back into the courtroom, I would just like to have it on record that I believe that this complaint is already in bad faith this morning, as I believe Andrew Bailey has been drinking alcohol or consuming alcohol. And part of the issue with what was going on with our co-tenancy was I opted to move out because he has a problem with alcohol and cannot stay sober and keeps going in and out of detox facilities and inpatient rehabilitation facilities. And when we moved into this residence that we're discussing right now, it was for me to even move in, it was agreed that I would be on the lease because of his issues with alcohol, and I didn't want to have any sort of repercussions or consequences because of it. I don't know if either he is lying to the court or if the landlord in this case had misinformed him, but that is not correct. I did give the landlord a 60-day notice that I would be moving out by the end of March. So he knew full well that I was leaving. And because of Mr. Bailey's abuse of alcohol, his terrorizing of me and harassment, I had asked that the landlord not let him know because I didn't want to have any extra issues or conflicts with him. And that way I could try. I had took a case to court previously when I had contacted the police, and he threatened me right in front of the police, and the police had made me leave that night, and I had went and filed a claim with the court. But in that case, I didn't have sufficient evidence at the time to proceed. And then he had checked himself into a detox facility, so things had calmed down and I had started packing. In regards to the amount owed, just like I had put in my statement to the court at this time, at no time did I agree, either verbally or in writing, that I would pay half of anything. As I've been extrapolating here, it was hard to have any sort of communication with him at all, because he was either drunk or he was away at a detox or an inpatient facility.
All right, thank you, sir. All right. In any case, when plaintiff's making a claim, they've got an obligation to prove their claim by a preponderance of the evidence. It means by the greater weight of the evidence. And in this case, the evidence has been presented as pretty scant. Now, you've both referenced a lease, and I'm going to note that there is no lease placed in evidence in this case. But even if there were, the lease is an agreement between the two of you and a landlord, and the landlord's not a party to this case, and the lease is not an agreement between the two of you. You may have an agreement, but the court doesn't know what it is because it's been insufficiently proved. And so, quite frankly, Mr. Bailey, you failed to carry your burden of proof here to show that there was some kind of enforceable agreement between you and Mr. Wohl with regard to these expenses related to your shared living arrangements. There may have been one, but is insufficiently proved. So there's no basis on which the court can rely to make a finding that Mr. Wohl would owe you any money for failure to comply with the terms and conditions that were agreed upon by the two of you. That agreement is just insufficiently proven. So for that reason, I'm going to enter judgment in this case in favor of the defendant, Mr. Wohl. All right, and I'm writing that judgment here. I will file that with the court clerk, and it will be available to both of you at any time. All right, and that will conclude this matter for today.
Thank you, Your Honor.
Oh my dear God. Hold on. I have technical difficulties, ladies and gentlemen, because I'm your lone wolf Oozle, and that's what I do is when we get to the very end of the video and I've been having issues all night long, I take drastic actions and end up having technical difficulties at the very end of the freaking, oh my God, I broke it. So I'm trying to get the wolfy head to work right now. I want you to have your wolf. What can I say? Hey. The wolfie has made its appearance. Besides, I can't go to the very end screen without having something covering this ugly mug of mine. You don't want to see this. It's not pretty. But I am here, ladies and gentlemen, and thank you for being here. I have a lot more coming up tomorrow. I was just about to bring up the little folder here where I have tons of stuff to watch. Oh my God. I have a Webster case from today. The suppression hearing. I want everybody to see that. I want us all to watch it together. We're probably going to do it tomorrow night, though. Not for the weekend show. I also have a big old family feud with Judge Hessling. We're probably going to watch that on Sunday. Those are both a little bit over an hour. Tomorrow, I got a Judge Johnson case where there's a thieving caregiver, somebody who's taking care of a guy with dementia who decides they want to steal from him, and I think that might be an interesting one for us to watch. I've got a place where the landowners are selling their land and then cutting down all the trees before the land changes hands. I got one with Judge Hart that might be kind of fun. I got a few things here. I'm pretty sure I got some Middleton in my back pocket someplace. That's all coming up tomorrow in about 12 hours. Yeah, maybe a little bit over, like 13, something like that. Xfinity, you only got to last another minute and a half, dadgummit. I know it wants to crash out. Oh my God. Everything goes wrong all at once. I love you all so very much. Thank you so much for hanging out with me. Thank you so much, Kieran. Thank you so much, Dobby. Thank you so much, all of my friends. Charlene, Tut. Oh my God, thank you. Thank you, thank you, thank you. Rhonda Ann, Mama, Becky, Specs, Donald, Felix, all of you participating in chat. Love you all so very much. Rahul, great to see you. I hope your friend loves the Dune series. I hope they read all of them. Every single one of them, the whole story. The story of Leto the Great is one of the best in all of history. And Felix, thank you out there. Becky, thank you out there. Tev, XP, Brecken, it's your fault. You should hear it from me. It's your fault. And it's my fault that it's your fault. So I take full responsibility for that. Specs, thank you so very much. Everybody, I'm tired. It's time to go get drunk or something. I don't know. Call Mama, check on her. But for now, I'm your lone wolf Usul, and I am out. Oh, you're going to watch a 10 p.m. movie? I gotta know Bat Boy is back. Are you going to watch The Back Rooms? Is that the I want to go see The Back Rooms so bad. I just found out that it even existed as a movie. Like A24 made it. And it's a Zane Back Rooms. It's gotta be good. For those of you who don't know, it's a YouTube thing. Go find out. It's not Ferris Bueller's Day Off. And on that note, I got nothing else. Get out of here. I'll see you tomorrow. There'll be a lot more tomorrow. Bye.